Good afternoon, everyone, and welcome to the fourth and last, but not the least, in our webinar series on the changes introduced into UK data protection law by the Data Use and Access Act 2025, the DUAA. My name is Renzo Marchini, and I am a partner in the data team in London, and thank you so much for joining us. I'm sure a bunch of you have been listening to previous episodes, but those that have only just tuned in today for the first time, we're giving an overview of key changes in the DUA as they apply to data protection law, but there's other parts of the DUA out there which we're not covering, such as provisions on smart data, very similar in intent to the EU Data Act, and provisions on amending registers of births and deaths and so on. Today, I am joined by Nuria Pastor, a director in our team, and as per tradition now, is the fourth, she'll do most of the talking. We will finish within 30 minutes, that is at 4:30 p.m. We'll speak for around 20 of those minutes, and we've allowed plenty of time for questions. Please do ask questions using the Q&A function on your screen as we go along. It might be convenient to take them as we do go along. Otherwise, we've got some time at the end. And if we do run out of time, we will respond to questions posed in writing. We will send you a copy of our slides and a link to a recording of this, and that will also be posted on YouTube. So quick reminder then of the 4 webinars. We've already covered overview and legitimate interest, data subject access requests, complaints, automated decision making in children, cookies and marketing and purpose limitation. And today it's all about data transfers, 3 separate topics: data transfers, research changes, and changes to the ICO's role. Quick recap, maybe if we go to the next slide, of what we have covered. You do go and look at the YouTube recordings of them, but at the very highest level, we talked about a timeline of 12 months, i.e. by June 2026, for all these provisions to come into force. Some already in force, those in relation to the DSAR regime. We talked also in the first episode about changes to legitimate interests, a new recognised legitimate interests, public task disclosure requests as an example. We talked about changes to the DSAR regime, reasonable proportionate searches and stop the clock now have a statutory footing and not just the benefit of ICO guidance. We talked about a need for a complaints procedure, which all data controllers are now going to have to make available in relation to any privacy complaints made by data subjects. We talked about greater flexibility for automated decision making, the removal of a requirement for one of those 3 conditions when you're not using special category data. PECA fines, currently capped at £500,000, will now be put into line with the GDPR maximum fine of 17 million, or a percentage of turnover. Cookie exemptions are being expanded. We have analytics cookies no longer needing consent if they fulfill certain requirements. We talked about direct marketing, in particular the fact that soft opt-in will be available to charities. And lastly, we talked about purpose limitation, and some secondary uses, e.g. data being used in emergencies, will now be deemed automatically compatible with the first use. And now I'll hand over to Nuria to introduce what we're going to be talking about.
Thank you, Renzo, and good afternoon, everyone, or good morning, depending on when you're joining from. So today we're going to, as Renzo quickly described earlier, we are going to touch on 3 topics: international data transfers, changes to scientific research provisions, and changes to the ICO role, and actually also the powers of the ICO. And then we'll take some questions at the end. So as you can see, there is a packed agenda. So I'm going to move us on to the next slide. and to the international data transfer section. So the DUAA introduces many changes to the provisions restricting international data transfers under the GDPR and the Data Protection Act 2018. Today, we're going to be focusing on the changes to Chapter 5 of the GDPR, as they are the changes that are more likely to be relevant to our audience. But however, we wanted to flag that DUAA also amends Chapter 5, Part 3 of the Data Protection Act 2018. And these are the provisions that cover international transfers regarding law enforcement processing. As I say, we won't focus on this. So let's have a look at the changes to Chapter 5 of the GDPR. You'll all be familiar with this chapter. So we are going to go through the changes to the different articles and new articles that have been introduced by DUAA. So first of all, there's quite a lot of redrafting. There is a bit of rejigging of some provisions and where they are. The first thing I wanted to highlight is that there is a new Article 44.A. This provides that international data transfers can only take place if the GDPR provisions are met and one of these three scenarios apply. And these three scenarios are, you will all be familiar with these, are whether the transfer is approved by the Secretary of State under what we would call under the EU GDPR an adequacy decision. But here under the DUAA and the new provisions of the GDPR, it's a regulation of the Secretary of State. Even though under DUAA it is a regulation, for the purposes of today's webinar, I'll be still talking about adequacy decisions just because it's the terminology that we are all used to, and it makes it easier to understand. Then the other scenario would be that whether the transfer is subject to appropriate safeguards, like SECs, which we're all familiar with, or the last one is when the transfer is made in reliance of a derogation. Again, we are also familiar with the derogations in Article 49 of the GDPR. So moving on to the changes in Article 45. So the DUAA introduced three new articles, 45.A, B, and C. And these are about the provisions, these provisions are about transfers based on adequacy decisions. What these new articles do, they regulate in more detail how the Secretary of State will make these decisions, these adequacy decisions, to approve transfers to a particular country or an international organization. And the Secretary of State will only make such adequacy decisions when a new data protection test is met. And this data protection test, I'll speak about this a bit more later, but it's quite one of the most important changes introduced by DUAA. The main takeaway in relation to the data protection test is that the standard that is used to assess the importing territories under legislation changes so that the legal test that the Secretary of State will be looking at when assessing a potential third party, to a third country to be a beneficiary of an adequacy decision, is that the protection to the individuals with regards to the processing of the personal data is not materially lower to the protection provided under UK data protection law. Also looking at changes to Article 46. Article 46 of the GDPR is amended to codify the Schrems Doctrine, which that again we're all familiar with, the EU Schrems Doctrine, which sets out that controllers or processors carrying out international data transfers are required to carry out a transfer impact assessment in relation to the transfers when an adequacy decision is not in place. This is in addition to putting safeguards in place such as SECs or BCRs. Moving on to the introduction of new Article 47A, this mainly sets out that the Secretary of State may issue new standard data protection clauses. We'll need to keep an eye on these clauses and how they may be used in the future, including whether they will replace existing standard clauses issued by the ICO in the last few years. But we do expect the ICO to issue guidance on this point. So we'll just have to keep an eye out on this. As you can see in the last bullet, I refer to some amendments to Article 49. I'm not going to stop with this because they are mostly, they simply address necessary redrafting and cross-references due to the use of new terms and numberings and so on. But I will stop for a moment on Article 49.A. This again is a new article that is inserted by DUAA into the GDPR. And Article 49.A sets out that the Secretary of State may restrict transfers to a particular territory by regulation for reasons of public interest. So similarly to the ability to decide whether a country is adequate, the Secretary of State can also decide if a country cannot be an importer of personal data exported from the UK for reasons of public interest. This is not a new thing. This is not a substantive change, if you like, but because this is already covered under the Data Protection Act. But it's curious that the DUA seems to seek to consolidate some of these provisions from the Data Protection Act to the GDPR, and this is one of them. So as you can see, many changes to bear in mind. Let's move to the next slide, where I look a bit more at the data protection test. So this slide shows a snippet from Article 45.A, which sets out the criteria in which adequacy decisions will be made by the Secretary of State. And this is, as you can read, that the protection afforded to data subjects with regards to the personal data process is no materially lower than the protection afforded in the UK. And as you can see on the box on the right-hand side, this test will not only be applied by the Secretary of State when making the adequacy decisions, but it will also be applied under other circumstances and due to the new provisions of the DUA introduced into the GDPR. So controllers and processors, when they carry out transfer impact assessments, will also take this data protection test into account. And also the Secretary of State, when drafting the new standard data protection clauses, which I mentioned under the new Article 47A, will take into account this new test. This legal test is lower, it's a lower standard than the one set out under Schrems. And as you will all remember, the level of protection afforded by importing organizations or countries must be essentially equivalent to the protection provided under EU law. So we go from essentially equivalent to no materially lower. So we'll have to wait and see what difference this makes in practice. So this has been a quick summary to the changes in relation to the regulation of data protection, of international data transfers. So, but I guess we're all wondering what happens next. Are things going to change rapidly? What do we need to do to adapt to the new articles that are going to come into the GDPR? Well, these provisions don't come into force yet. They will come into force in the next, they'll be applicable in the next few months. So there is time. We expect that we'll need to keep an eye out to the decisions of the Secretary of State in relation to adequate countries. So it might be that in the future, given that the test is lower, it might be that further down the line, the list of adequate countries under UK law will increase. We may also see updated transfer impact assessment tools from the ICO, again, based on the new standard. And also new standard clauses by the Secretary of State under Article 47A. There is no doubt that there's going to be an ICO consultation and that there's going to be updated guidance on this point. So we'll have to keep a lookout for that. There is, however, no need to panic. And the immediate takeaway here is that if you are relying on adequacy decisions at the moment in order to carry out your data transfers, this will continue to be adequate after these provisions become applicable, unless the decision is voided, and that organizations will not need to update their existing contracts based on standard contractual clauses, which are valid before these new provisions become applicable, as they will continue to be valid. However, they may be in the future replaced. So again, we need to keep an eye on this. These sort of transition considerations are set out specifically under DUAA, under Schedule 9 of DUAA. So as I say, we'll have to keep an eye on it, but as you can see, the last questions, will there be benefits? There are likely to be benefits as the standards are lowering, but I think we will see this, further down the line. And I'm now moving on to our next topic, which is research processing. And I'm just going to go through this quickly because I do want to explain, and the time is limited. I want to explain the new ICO powers in a bit more detail. And also the reason why we can go through this quickly is because in relation to the scientific research processing, what the DUAA is doing is codify some existing recitals of the GDPR. So the main points I wanted to highlight are that the definition of scientific research is amended to ensure that it is broad. So as I say, the DUAA codifies existing recitals of the GDPR confirming this point. You can see that recital 159 of the GDPR states that the processing of personal data for scientific purposes should be interpreted in a broad manner. So the DUAA is just confirming and codifying this. The other important point is in relation to consent. So again, what DUAA does is update the GDPR by codifying the content of the GDPR recital, setting out that consent obtained for scientific research may be broader than it would normally be required under the GDPR. This is to accommodate situations where the researcher is unclear of the purpose, of the specific purpose of a study at the start of the study. And what these new changes will do is that they will give more legal certainty to organizations carrying out this type of scientific research processing activities. One thing to remember, though, when we talk about consent in this context, is that generally consent is not a legal basis that's commonly relied on under the GDPR for purposes of scientific research. And those of you who are familiar with these processing activities will know that the HRA has issued extensive guidance on this. However, to the extent that consent is relied on, consent may be broader. The last point I wanted to make is that the safeguards introduced also by a new chapter that's introduced into the GDPR. This is chapter 8A. For instance, and these safeguards are in relation to the processing for, as you can see, research, archiving, and statistical purposes, and they are to require additional safeguards, for example, the application of the principle of data minimization, as well as preventing processing, which leads to harm to data subjects and so on. I won't go into detail on this, but yeah, these are the main points in relation to research processing. So I'm rapidly going to move on to the ICO and the changes relating to the ICO. These are only the main changes. I haven't detailed them all. First of all, there's a structural change to the organization. And this is in line with changes that have been experienced by other public bodies. So the ICO, which is the Information Commissioner Office, becomes the Information Commission. The DUAA also defines a strategic direction for the ICO, and it includes a new duty to take in for the ICO to take into account the specific criteria when making decisions, including the desirability of promoting competition or innovation, public and national security, and so on. So these, again, in terms of the ICO strategy, are codified within, by DUAA. The ICO must set out as well a strategy. It must keep it under review and make it public. The ICO will have a new duty to consult with other regulators regarding issues such as economic growth, innovation, and competition, and to consult Parliament under certain circumstances. What DUAA does is also set out that the principal duty of the ICO is ensuring appropriate level of protection for personal data, having regards of the interests of the individuals, controllers, and others, and the public interest, and also the promotion of public trust and confidence in the processing of personal data. An interesting point also in relation to the changes introduced by DUAA to ICO activity is the issue of transparency. I think thanks to DUAA, we're going to have more visibility about the ICO's performance and activities, which may be useful to controllers and processors. So first of all, the DUAA introduced two new transparency requirements. One is the requirement for the ICO to publish an actual analysis of its performance against certain key performance indicators. Secondly, the ICO is also required to publish an annual report on its regulatory activity, including the nature of the investigations, the time that they have taken, and the powers that have been used for each investigation. Lastly, in terms of enhanced powers or enforcement powers that have been enhanced by DUAA, what I wanted to highlight is a number of things that may make those who are at the receiving end of ICO's enforcement activities, it might make our life a bit more difficult, if you like, because it does enhance the ICO's powers. So on the one hand, DUAA introduces provisions to clarify that the information notices issued by the ICO may require recipients to provide documents, not only information. It also extends the scope of the assessment notices that the ICO can already issue under the current regime by requiring an organization, for instance, in the context of an investigation, to commission and pay for a report. So, for example, if in the context of an investigation, the ICO comes across certain technology or, we can find that there's an obvious example of technology such as encryption that the ICO would like to understand better, it may require the organization to commission a report and pay for it. Regarding the timescales for issuing a penalty notice, the ICO is given more time to do it. There's a 6-month window, but that can be extended as soon as practicable thereafter. However, the ICO is required to say to the targeted organization when it is not planning to issue a penalty notice in the context of an investigation.
No, thank you. I'm concerned about time. We have about 5 minutes left. I've got at least one
Yeah, I
question. I want
have
to allow
two
time for more.
sentences.
So
Yeah.
yeah, thank you.
Yeah, no, I am aware of timing. There's also very quickly a new power to require a person to attend an interview. So until now, this was voluntary, but under the new provisions introduced by DUAA, this is, the ICO has the power to require that. And if the individual does not attend the interview, this can be considered an aggravating factor in future enforcement activities. And I just wanted to flag last sentence that some of these changes in relation to enforcement notices and requirement of documents became applicable in August this year. So I'm moving on to questions.
Thank
Oh,
you. So
actually, yeah, sorry, there was another slide on key actions, Renzo, but I think I've mentioned most of these already.
okay, so let me take the one question that's there. Someone else asked me about do we need to redo we got a bunch of transfer impact assessments. Do we need to redo them for the UK?
I think the short answer is no, because obviously global organizations will be relying on and will have carried out TIAs based on the Schrems criteria, if you like, and the EDPB guidance. And what the UK does is lower the standard. So if you're already complying with a higher standard, you wouldn't need to redo this to comply with a lower standard.
Yeah, correct. I suppose I might add to that if you had UK only transfers and you were doing some new assessments in relation to a particular destination country, then you might want to look at the form that you've used. And we're certainly looking at our portfolio of TIAs with the UK in mind for one client. Yeah, if it's UK only, it might be life a bit easier to do your assessment. You might redo it in those circumstances. So if anyone else got any questions they want to put in the Q&A? Otherwise, you want to let's maybe finish those points on your key actions, Nuria.
Yeah, thank you, Renzo. So yeah, as I've said throughout the presentation, I think it's important to keep an eye on the commencement orders for these provisions, also future ICO consultations and guidance. Some of these provisions are not super easy to understand, and it'll be good to have some ICO guidance to confirm next steps. In terms of the ensure you have a record of appropriate safeguards you rely on and your TIAs, very much linked to your question, Renzo. I think it's good to ensure that the quote unquote the house is in order, just to make sure that if there are any changes to SECs or new SECs, or if you may want to review your TIAs. It'll just be good to know what you have and that what you have is up to date, and just do a bit of perhaps a sort of a mapping exercise. And then in terms of ICO powers, the ICO will be more transparent, so we'll be able to have some insights in terms of what the ICO is doing, the regulatory activities, and so on. But on the flip side, the ICO will also have more investigatory powers, which may lead to more, it might become more costly to deal with an ICO investigation. And I know many organizations have procedures on how to deal with such regulatory investigations. So if those are in place, it may be a good idea to review those in order to adapt them to the new ICO powers. So, for example, the point that I just made at the end in relation to interviews, it will now be a requirement to attend such interviews if the ICO asks an organization to. So yeah, these are my quick takeaway action.
Thank you. Thank you very much, Nuria, and thank you everyone for joining. I trust that this and previous episodes have been helpful in giving you some of the answers, if not all of the answers you were looking for under DUAA. We will send slides and link to recording very soon. Please watch out for future webinars from the Fieldfisher Data Room. Do register for our invitations. And those of you in London may wish to join us for some in-person workshops that we offer. And we have some upcoming on privacy and the AI intersection. So with no further ado, I wish you all a brilliant rest of your day and week.